outside in Canada for euthanasia. I'm in court, and we're continuing to fight this. Even though in your law physicians are not required to participate as actively, they are required to refer, and that is the same thing as participating, even if you don't actually prescribe. So I encourage the legislature to vote no on assisted suicide. Thank you, and I'm going to pass the word to Julie. Julie, would you like to speak?
Sure. Hi guys, my name is Julie Hogger. I am a senior policy fellow down in Washington, D.C. for the Center for Human Dignity, and our greatest concerns with this bill are really around the folks who it marginalizes and leaves on the side. This bill really creates a class of citizens in your state who will no longer have the same protections that the rest of New Yorkers are afforded, which is the right to access care during some of the most difficult times in their lives. This may mean that folks with disabilities who rely on others to provide communication or make decisions on their behalf could be in harm's way or and truly die before naturally doing so. We also believe that those with non-terminal illnesses will actually see many loopholes in, and when the cost of their medical care gets too high or their insurance companies simply don't want to pay for those expensive forms of care anymore, they'll become terminally ill when in fact there's curative care out there available to them. We also know that this bill uses purposely loose and deceptive language in order to make it so that it would have natural expansion before it would even ever come back to this legislature again, and that also concerns us because it really isn't about folks who have 6 months or less to live. It's actually about a much broader group of people from the very beginning, and we see a huge problem with that, especially in a state that has recently declared a public health crisis with suicide.
Thank you. Thank you.
Hi, I'm John Verdone. I'm an elder law attorney and a litigator. I've been practicing for over 23 years now. With respect to elder law abuse, there are many, many cases already in the courts. The courts are filled with them concerning elder abuse, deception. People who have terminal illness are very likely to be vulnerable psychologically, emotionally, and susceptible to coercion, undue influence. That's already in the courts. The courts presently, it happens. Elderly people are coerced to give up their houses, to sign powers of attorneys, to sign trusts. It's happening every day. The courts have to decide these cases. And luckily, these particular elderly persons are still alive, and they can come back and potentially fight against the deception and abuse, or other family members who pick up on it can do it. But in this case, in assisted suicide, these people sign a legal document. They could be coerced. They could be not have the capacity, the right capacity. Capacity is an issue that the courts have to deal with all the time, in terms of guardianships, in terms of powers of attorney, and that has to be decided. And often doctors are called in, and there's a battle between doctors. 3-4 doctors can't agree whether the person had capacity or not. Here, the way this bill is presented, you have 1, maybe 2 doctors that are going to exclusively decide whether the incapacitated person or the terminally ill person has capacity. This is something for the courts to decide, not 1 or 2 doctors. And as I said, doctors can't agree. I have had cases where elderly persons have had their houses taken away, through powers of attorney. They were deceived, and it has to go to a trial, and doctors have to be called in. At least they have that option. Here, it's a fatal situation. They won't be able to come back and fight against being deceived. So I think that this bill has a lot of problems with it, a lot of gaps, a lot of loopholes, and it's not a good bill overall.
Thank you so much.
Well, thank you, and thank you for inviting me. I just wanted to just present Jeanette Hall. Jeanette Hall spoke in Montreal, and Jeanette Hall was told by her doctor, by many of her doctors, that she had terminal cancer, and there was a little hope for her. and she qualified for the Oregon assisted suicide. This was over 10 years ago, almost 20 years ago, because the law came into effect in 1998. Dr. Stevens, who spoke about her case in Montreal, was able to convince her otherwise, and she's happy to be alive today. And she was able to attend her son's wedding, and that's how she was convinced. And there are many people like Jeanette Hall, many people like Mona Latour up in Canada, and Nadine up in Canada. And these are just a few people whose lives, and they represent many thousands of lives, who will be lost if assisted suicide is passed here in New York. Thank you.
Thank you.
Point. The bill does not require self-administration. I don't know if you're aware of that. It looks like it does. It's very clear. It says, the bill has language to effect that the lethal dose shall be self-administered. It would seem you couldn't get much more clear than that. But then if you read a later part of the bill, it talks about how the attending physician is empowered to take appropriate steps and also act in accordance with the bill. But I'll just focus on appropriate for now. So I asked Dr. Toffler when we were doing his declaration about, if someone can't swallow, would it be appropriate to prescribe medication that would be administered by injection? He said yes. Or else, also in his practice, like if he has someone who happens to be on a morphine drip or any drip, or on a feeding tube, and the person's asleep, and he doesn't want to bother them, if it's appropriate, he'll put the medication in that so he doesn't have to bother the patients. That's appropriate. So the appropriateness standard completely guts out the shall language of self-administer. At least that's the way I read it. It's at least arguable. And if we're talking about criminal sanctions, you need to have it clear. You can't prosecute someone for something that's not clear.